Okay, maraming salamat. Good morning to all of you. Welcome to this MCLE program. It's a totally new to all of us. First time yata ito na maka-attend tayo ng online MCLE. No? But for those who are teaching like me in the law school, ay magmula pa ho nung May, we have been on online classes. Kaya kahit pa paano nasanay na, no? But for this, allow me to share my screen to you. Paki-enable naman po yung screen sharing so that I could share my lecture para nakikita nyo at the same time yung aking okay. So, this is effective legal writing. Yan ho yung ating topic this morning. And I hope you bear with me until 5 o'clock. 10 o'clock lang pala tayo. So yan. So as we have done, we invoke the presence of God for those who believe in God, because the right to believe includes the right not to believe. But if you believe, it includes the right to act on your belief. Sabi ni St. Thomas More, yan ho yung ating patron saint, yun yung mas mataas, hindi yung nasa baba. Sabi niya, ito yung prayer ng mga abogado. Lord, grant that I may be able in argument, accurate in analysis, strict in study, candid with clients, and honest with adversaries. Alam nyo, in our days ngayon, parang bihira na daw ang honest. Sabi nila, honesty is such a lonely word. Bihira na raw ang tapat. Parang tanghali na lang ang tapat. Okay? Now, sometimes may mga na-encounter ho tayo na kabaro natin that in their desire to win the cases they are handling, they resort to some not so honest means, no? Okay. So sit with me at my desk and listen with me to my client's plaints. Read with me in my library and stand beside me in court, so that today I shall not, in order to win a point, lose my soul. That is if you believe you have a soul. Because if you don't, that is immaterial. Why? Sabi ho ni Matthew chapter 16 verse 26, for what profit is it to a man if he gains the whole world and lose his own soul? Or what would a man give in exchange for his soul? Again, on the premise that you believe you have a soul. Although hindi pa naman natin nakikita ang pare-pareho. No? Now, sabi ni Oscar Wilde, ito ho ay kakaibang writer from Ireland, kasi siya yung kauna-unahang openly admitted that he was gay. So yung mga panahon ho nilang yan, it was a crime to be homosexual. Pero inadmit niya. So matapang-tapang ho ito. No? Marami ho siyang mga articles, mga written work na lumalabas yung kanyang karakter. But anyway, preference niya, wala tayong magagawa. So siya ang kauna-unahan yatang, pag naging santo yan, baka yan ang maging santo ng LGBT community. Sabi niya, when I was young, I thought that money was the most important thing in life. But now that I am old, I know that it is. Okay na sana, ano po? Sabi naman ni Margaret Thatcher, I know you know her, siya yung dating Prime Minister ng Great Britain, it is not the creation of wealth that is wrong. So anong mali? It is the love of money for its own sake. So it's not money, but the love of money. Now, marami ho tayong mga kasamahan sa profesyon na nasuspindi o natanggalan ng lisensya. Dalawa lang ang dahilan eh. Pareho nagsisimula sa letter P. Yung isa pera, yung isa raw ay puri. Anyway, so, tingnan ho ninyo ito, no? Ang mga estudyante ko minsan binibigyan ko ng screen break kasi nagkakaroon daw ko na tinatawag na screen fatigue. If you have been looking at your screen for a long period of time, nagkakaroon ho ng screen fatigue. So from time to time, you have to take a break. Look at the beautiful things in life. Look at the green things. Ayan. So ang sabi ho ng mga eksperto, if these things in your screen are moving, the one looking at them is under stress. And the faster they move, the higher is your level of stress. Ayan, so very stressful naman ho talaga ang lawyering, especially nowadays. Lalo na't nandyan yung palagi yung threat ng virus, na we cannot see our enemy. At any time, anyone can be infected. And sad to say, wala pa yatang gamot. At yung vaccine parang puro puro dry run lang, no? Kailan kaya magkakaroon ng wet run? Anyway, so kung hindi naman daw gumagalaw, eh di wala naman kayong stress. Now, sa buhay ng mga lalaki, nagdadala daw ho na napakalaking stress ay another woman. Why? Ang tawag daw kasi ay mistress. May stress. But I have no personal knowledge. Ayan ho. Ang sabi ni Justice Joseph Story, the Justice of the Supreme Court of the US, the law is a jealous mistress and requires a long and constant courtship. So magmula pa ho nung tayo ay nag-isip na mag-aral at pumasok sa College of Law, hanggang ngayon, ang apakaraming difficulties ang kailangan natin daanan. Add to the fact that we have to maintain a good moral standing para manatili as a member of the bar. Again, you look at the negative, not negative, but the white yellow dot, yellow at ang appearance sa screen ninyo, for about 5 seconds, and then you look on the white part of the screen. So kung nakita ho ninyo yung nakikita ko, eh, pareho tayo na nakikita. So those were the days na uso pa yung mga negative, no? At hindi katulad ngayon na instant yung pagkuha ng picture. So what does it imply? Wala lang. Lahat ba talaga may ibig sabihin? Hindi. Ibig sabihin yan, sometimes things are not what they appear to be. Diba? So tulad nitong dinala nitong virus na ito coming from Wuhan, China, na ayaw nilang tawaging Wuhan virus. Eh, there are good things naman daw na nangyari. And we call it pandemic. So there are 2 words daw. Fun, masaya, no? Because happiness is a choice. In the midst of all the problems, if you choose to be happy, you can be happy. And yung endemic, endemic. So ito ay peculiar to a particular place. So sabi nila, happiness is particular to you. There are things that would make you happy that others would not be happy. So sabi ng isang writer, life is so short. Pursue the things that would make you happy. But in the pursuit of your happiness, do not cause the sadness of others intentionally. Kasi may mga pagkakataon na nagiging sad ho ang ibang tao, pero wala naman tayong intensyon na maging malungkot sila. Di ba? But as much as possible, let us make our goal to make ourselves happy and make others happy too. Okay? Ayan, sabi nga ni, when Pandora opened the box, all the evils and ills of the world came out. But there's one thing that remained, and that's hope. Diba? So let us just hope that hope would always be there. Okay, so ito ho yan, no? Tagal natin tiningnan yun nandun sa kaliwa, yung pala, ito yung nasa kanan talaga. So sometimes, hindi pwedeng pagkatiwalaan yung unang tingin. Anyway, so this was life before the computer. Some memory is something you lost with age. Yan, nagkakaroon ng memory gap. Although may mga gamot na daw dyan. A keyboard was for a piano. Pero may keyboard kahit yung ating computer and laptop. A web was a spider's home. Pero pag sinabing web, ito yung internet website. You can be a citizen. Ang tawag lang, netizen. No? A virus can cause disease, but ngayon, a virus can erase all your files. Kaya mag-ingat sa mga virus. Then a cursor, use profanity from the word curse. Pero yung cursor ngayon, yung nagbiblink dun sa ating computer. No? So yung, then, a mouse used to be a pest. Ayaw nating hawakan. Pero ngayon, ito ay laging hawak natin kapag, kasi hindi mo maigagalaw yung cursor pag wala kang mouse. Mahirap pagka yung fingers lang ang gagalaw. And then, a mouse pad, ay yung pinapatungan ng mouse. It used to be where the mouse lived. Yung mga lungga. Ngayon, pinapatong natin yung mouse dyan. And a hard drive was a long trip on the road. Kung kayo ay meron ng RFID. Ano? So, I would normally drive from Quezon City to Bicol. Medyo hard drive yan, long drive. But now, a hard drive is where you store your data. At ito, hindi na uso ito kasi USB na ngayon, di ba? But nung unang panahon, if you have a 3.5-inch floppy, you just hope nobody would find out. Okay. Well, whether we like it or not, in our country, English is the language of the law, and it is the language of the bar. I have been talking to several bar examiners in the past, and one comment that they would normally give is that bar examinees have a very poor command of the English grammar. Well, understandably, we are not native English speakers. Diba? Kung paano na kung di umalis yung mga Espanyol, di Spanish ang ating ginagamit sa korte. Naalala pa ninyo yung Kodigo Penal at yung Kodigo Sibil. Diba? So when the Americans came, they influenced us or probably forced us to speak their language because they could not speak our language. So it stuck with us that until now we are using an alien language to communicate in law and in the bar. Diba? So but why is English so hard? Di katulad ng Pilipino, you say what you mean and you mean what you say. You spell what you write what you spell. Diba? Ayan. Well, we'll begin with the box. Anong plural ng box? Diba? Boxes. Tama naman. Lalagyan mo lang ng ES. But the plural of ox ay hindi oxes. Oxen. Pluralization pa lang yan. Diba? And then of course, one fowl is a goose. Pero hindi po pwedeng sabihin gooses, di ba? Geese na yun, dalawa. Yung moose, hindi naman miss. Okay? And then you may find out a lone mouse, pag isa, pero a nest full of mice. Bakit ganon? Pero yung house, hindi naman pwedeng highs ang plural. Diba? Hindi high, hindi nice, kundi highs. Okay? And then, if the plural of man is always called men, bakit yung pan hindi pwedeng pen? Okay? So, inconsistent. Then, if I speak of my foot and show you my feet, and I give you a boot, would a pair be called beat? So, hindi, di ba? Then, of course, if one is a tooth and a whole set are teeth, why shouldn't the plural of boot be called beat? Okay? Only the Americans could answer that. Then one may be that, and three would be those. Yet, hat in the plural would never be whose. And the plural of cat is cats, not cows. Okay. Then of course, if we speak of a brother and also of brethren, marami, but though we may say mother, we never say medren. Okay, so that's why English is so hard. Then the masculine of pronouns are he, his, and him. But imagine the feminine, she, she's, and shim. Iba. Okay. So, reading session muna tayo. Try to read what's in your screen. I'm giving you 2 hours. Hindi pala. 10 seconds lang. Okay. If you have read this and you could understand, no problem. That's just normal, no? That's called typoglycemia. Typoglycemia refers to the ability to understand the meaning of words in a sentence as long as the exterior letters of each word are correct and all the letters of the word are present. Yeah? So, but somehow, spelling is very important, as we would find out later on. Kakaproblema yung iba because of spelling. Okay. Now, we proceed to reading and writing. Sabi ni Francis Bacon, an English author and philosopher, reading make it a full man. Conference ay ready man. So ready na tayo dahil nasa conference tayo ngayon. And writing an exact man. Okay? So, sabi naman ni Edward George Earl Lytton, Bulwer Lytton, siya ho yung original author ng The pen is mightier than the sword. Diba? Through this, beneath the rule of men entirely great, the pen is mightier than the sword. In his play Richelieu. So what do we do? Sabi ni David Henry Thoreau, an American author, write while the heat is in you. Diba? Magsulat habang init. Kaya lang minsan may mga advice naman na kapag galit ka, huwag ka muna magsusulat. Kasi your written work would reflect your emotion at the time of writing. Tama? At yung mga writers daw, they write best under extreme conditions. When they are inspired or when they are in despair. Okay, the writer who postpones the recording of his thoughts uses an iron which has cooled to burn a whole wheat. So, huwag ipopostpone ang ating mga gagawin. He cannot inflame the minds of his audience. Unfortunately, may mga kasama tayo sa profesyon na encounter natin na inaantay talaga yung deadline. Pagdating ng deadline, doon lang siya magpa-file ng motion at motion for extension. Diba nakakapikon yung ganun? Antayin mo yung deadline tapos motion for extension na matatanggap mo. Anyway, so even in the Bible, kasi almost 1/3 of the world population believes in the inerrancy of the Bible, that the Bible is accurate, that there are no mistakes, there are no contradictions. Well, that's their belief. We respect that. But they cannot force their belief on others who do not believe as they do. Diba? Okay, so in the Bible, and sabi, Jesus answered, "It is written, man does not live on bread alone, but on every word that comes from the mouth of God." So writing. And another passage in the Bible, sabi dyan, "It is written that you may believe, and that by believing, you may be saved." Yun. Now, insofar as the Supreme Court is concerned, there is nothing more effective than the written word by which counsel can persuade the court of the righteousness of his cause. Kasi pag sinabi nating hearing minsan, ang sasabihin sa atin ni judge, put that in writing. So put your motion in writing. So kailangan kumbinsihin natin si judge na maganda yung ating cause through written submission. Because unlike in the United States na meron silang trial by jury in which you can talk to the jury and the judge is listening, here, there is only one person listening to us who would decide. Somehow, pati daw yung clerk of court. Anyway, diba? But normally, it is the judge who makes the decision. He and he alone can make the judgment. Okay. For if truth were self-evident, a memorandum would be completely unnecessary and superfluous. That's from the pen of former Chief Justice Renato Corona in that case of Social Justice Society versus Atienza. Okay? So kailangan isulat. Ang problema natin, sabi ng isang dean ng law school sa Amerika, Yale Law School Dean Fred Rodel, most legal writing is atrocious. At siya yung author nung yung librong nakikita ninyo, ano? I have a copy of that book. Ay, kawawa yung mga lawyers dyan. Pero siya mismo ay dean ng law school. Woe unto you, lawyers. Hala, parang biblical yan, di ba? According to Fred Rodel, yung dean nga ng Yale Law School, there are two things wrong with most legal writing. Ano yung mali? Sabi niya, one is style, the other is content. OMG. Yan doon, napakalaking avatar. Abatarantado, bakit naman ganun? Eh di wala nang tama. Content and style are both wrong. How can that be? Okay? Well, especially if you would let a non-lawyer read our written work, then they would not understand what we mean. Okay? Probably yun yung secret of the trade. Because if an ordinary mortal would understand the written works of a lawyer, there would be no need for lawyers like us. Di ba? Okay. So, kailan ba tayo natutong sumulat? At where did we learn to write? We learned the rudimentary rules in grade school, of course. Yun yung formal schooling natin. Because prior to that, we were taught by our parents at home. So, hindi pa formal yan. Pero formative years na yun. So, whatever we learn from our homes, we bring that to our school. But the rudimentary rules, in grammar particularly, are learned in grade school. Unfortunately, some of those rules were not accurate rules in legal writing. Right? Why? The grade school teacher who told you not to start a sentence with and but is mistaken after all. Because according to Judge Mark Painter, the use of and but to begin a sentence is one mark of good legal writing. Pero subukan mo yan sa formal team, sa high school or sa elementary, pagagalitan ka ni teacher. Do not start your sentence with and but. But according to experts in legal writing, that is a good mark of legal writing. If you use and but as a start of your sentence. Okay? Now, lawyers always write. According to Abraham Lincoln, as lawyers, what we do most is to write. Diba? The lawyer's time and advice are our stock and trade, but we express the advice in writing. And we use our time in drafting, communicating mostly by written word. Sometimes, though, we fail to remember that the first rule of writing is to communicate. Our objective in writing is to communicate. So when you write, you are not writing for yourself. You are writing for the people who would read your written work. That's what we should remember, that when we write, we communicate. Okay? Ay, saan ba nanggaling ito? Yun daw. It has been a common belief daw that sharks will not attack lawyers. Oh, kahit na shark-infested water, we can swim daw. Why? Professional courtesy. Well, anonymous yung writer, ayaw niyang mademanda siya. Okay. So what are the problems with legal writing? One problem in law school is that we read cases written by justices who are not so good writers. O yung staff nila nagsulat. Diba? Alam naman natin pare-pareho yan. Or, of course, maraming magagaling na mga writers. Now, when I was first year in law school, I enjoy reading cases written by Justice Isagani Cruz. Kasi nga naman, magaling yung kanyang presentation, and as if you are not really reading a legal treatise, no? Kasi marami siyang mga isinasama na literary at saka historical figures or things, no? Okay. Of course, meron kayong JBL Reyes. But the problem is compounded exponentially by the law students' encounter with other legal writing, like lease, contracts, pleadings, and some of them hardly changed from Shakespearean era. Diba? Bago tayo sa law school, o kung wala ka pa sa law school, nagpapanotaryo ka. Sa bandang dulo, ang normally sinasabi ng mga sinaunang notary public, affiant further saith not. Ha? Ano daw? Shakespearean. Diba? Wala ka na nga sinabi mo pa. So, pero yung mga bagong notary public, parang wala nang gano'n, no? Sa mga affidavit. Merong isang matandang kapitbahay, sabi niya, attorney, abogado ka na pala, igawa mo nga ako ng abit-abit. Anong abit-abit? Yung pala affidavit. Anyway, so, what are the rules for good writing? Writing is a skill that can be learned. Not everyone is born to be a writer. Diba? Not that any of us can learn to be a Cardozo or a Holmes. Ito yung mga magagaling na magsulat na justices ng US Supreme Court. But we can substantially improve our communication by learning a few skills, a few tricks, and unlearning some rules that get in the way of good writing. Alam niyo, sabi nila, sa old habits never die, but we are not sure whether or not such habit is really good. Mahirap alisin na nakasanayan na. Okay. So number 1, know your audience. Okay? Until 10 o'clock, we have 200 rules. Kaya ba, Jude, itong 200 rules na ito in 2 hours? Palagay ko hindi. Ano? Sige, shortcut na lang natin. Huwag ng 200. So rule number 1, know your audience. That is the first rule in all kinds of writing, whether legal writing or any kind of writing. Kanino ka ba sumusulat? Para kanino? You're not writing for yourself. You are writing for the people whom you intend to read your written work. Okay? If you're communicating to a court, of course, know the court. Be familiar with the rules. Of course, sa atin, standard ang rules of court natin. Although, as I always tell my students, if you want to pass the bar, know the rules of court. Naka-amend lang ho yung rules 1 to 35, no? Pati yung rules on evidence. But if you want to win your cases thereafter, know the rules in court. And these are 2 different things. As any practitioner will tell you that, di ba? Kasi iba-iba ng interpretation minsan eh. Like for example, judicial affidavit rule. So, judicial affidavit ka, i-present mo yung testigo, there are courts that we have experienced na sasabihin, do not let the witness identify your attachment, your exhibits. Why? Nandun na yan, ipa-authenticate mo na lang sa kanya. But there are courts that you would encounter which would require your witness to identify all the attachments in that judicial affidavit. Eh ano ba talaga? Diba? So these are the rules in court, no? Ayan. And then, the members of the court. Sino ba ito? Kasi there is a common belief, although not true naman, na kapag yung judge ay dating fiscal at criminal cases ang criminal case yan, normally, convicted daw. Pagka lawyer dati yan at nag-judge, normally acquitted yung akusado. Well, that's an urban legend naman, no? Hindi naman palaging totoo yan. So, what are the preference of these individuals? Although sa ating legal ethics, bawal na kinikilala mo si judge, di ba? Okay. Then part of knowing your audience, are you writing a brief for an appellate court? Siyempre, iba na yan. A trial brief, an opinion letter to an in-house counsel. Kung in-house counsel, pareho kayong abogado, nagkakaintindihan kayo. Pero nag-iiba yata ang level of understanding pag na-appoint sa korte. Or a letter or an opinion to a highly knowledgeable but a lay person. So hindi natin po pwedeng gagamitan ng mga legal gobbledygook, baka hindi niya maintindihan. Diba? Okay. If you are to persuade a judge to rule in your favor, or an adversary's lawyer to pay you or money or demand less money, you want to be persuasive. But how do you persuade those who would read your work? The most important step in persuasion is communicating clearly. What do you want the other person to do? Ano ba ang gusto mong gawin niya? Eh di syempre manalo, di ba? That's the objective of majority of lawyers. But according to our CPR, the objective is not to win, but is to see to it that justice is done. Okay? Now, rule number 2, front load your document. Okay? As in all writing, organize your document to be front loaded. What do we mean by that? Put your best foot forward, sabi dyan. Put the most important material up front. Unahin natin yung pinaka-importanting issue na gusto nating mag-rule ang korte. Saka na yung mga peripheral issues. Readers understands much more easily if they have a context. Para saan ba ito? Okay? So kaya unahin mo na kaagad. And of course, the judge knows little about the facts of your case. Kasi pag alam ni judge yan, under the judicial Code of Judicial Conduct, mandatory inhibition yan. They may personal knowledge siya about the case. Okay. He will only know what are in the pleadings until you explain it. So explain mo in your pleading and strive to explain the case in a way that an average person can understand. Okay? Do not presume that because you understand, the judge would also understand. Do not presume that you understand, the other persons who would read would also understand. That's a common mistake of those who are writing. Okay? And of course, make it easy for the reader. Do not make it hard, otherwise wala nang babasa niyan. Diba? Explain your case in the first 2 or 3 pages. Ang problema lang natin dito, in our country, meron tayong format na sinusunod eh. Kaya nga itinuturo yan sa law school, yung legal forms. Diba? Kaya lang minsan yung mga professor naman natin sa legal forms, 1 o 2 beses lang tayo na-meet sa isang semester. Diba? Puro na lang assignment ang binigay. Hindi pa man nag-online class, mahilig na sila sa asynchronous. Bakit? Di sila nagpapakita. So another rule is to have a non-lawyer read your work. And if that non-lawyer reader can tell you what the case is all about, then you have written a good document. Because that can be understood by an ordinary mortal. Now, another rule is that frame the issues in few words. You may have seen cases decided by the court in which napakaraming issues, no? At ang hahaba ng phrasing. So the most important part of the trial or appellate brief or even a memorandum is framing the issue. Ano ba talaga yung mga issue? Ano ba yon? What is the question you are trying to answer for the court or the other lawyer? So normally, we were trained in law school to digest a case. So babasahin yung pagkahaba-habang kaso, you have to identify the facts, and then the issues, and then the ruling of the court. Ang tip ko sa mga estudyante ko, when you digest a case, do not digest the case that's already digested. You digest the original, di ba nakakadiri naman, dinigest na iba, ida-digest mo pa. So digest the original, not the digested one. Yung iba kasi, nag-shortcut. Yung digested na, yun ang dinadigest. Kaya pag tinanong ni teacher, ano ang kulay ng kotseng nakabangga? Like for example, in torts cases, hindi niya na alam. And then, ang sasabihin, ichichismis ka, ang sasabihin, yung teacher na yan, napaka-trivial ng mga tanong. So I would tell my students, that's not a trivial question. That is a way for the professor to determine whether or not you have read the case in its original form. Because that kind of question would not appear in the digested form. You can only find that in the original. So that's one way of finding out for the professor whether you have read the case in its original or not. Okay? Now, what do you want the court to decide? Siyempre, kaya ka nag-file ng kaso, gusto mong manalo. So, ipaliwanag mo sa korte, bakit kailangan ikaw manalo at matalo ang kalaban mo? Okay. So, do not start writing your brief or memo until you have a succinct statement of what the case is about. Pinadigest yung 20 pages na kaso. Ang digest niya, 21 pages. Hindi niya naintindihan ito. Why? You must do this in 50 to 75 words. And the problem with us, we cannot, anong tawag dyan? We cannot write concisely. We have the liberty of writing so many words. Ito kaya ay dahilan kung bakit per page ang ating pleading, per page ang bayad. Sabi ni Judge Mark Painter, if you can't explain the case in 75 words, you do not understand it very well, and you do not expect your reader to understand it also. Yeah? Now, 4, write the facts succinctly. So the first statement is to give a context, a roadmap. Be concise. The fewer the words, the more memorable is the point. Kasi hindi naman naalala ng mga tao yung napakahaba nating sinusulat. Diba? Okay. Sabi ni Blaise Pascal, dahil ngayon ay araw ng mga buwan pala ng mga puso, tapos na yung araw, ako naman nag-aantay kailan ba darating yung araw ng mga utak. The heart has its reasons of which reason knows nothing. So very memorable. And even the Supreme Court quoted that. Anong sabi? If the two eventually fell in love, despite the disparity in their ages and academic levels, this only lends substance to the truism that, ayan, quoting now from Blaise Pascal, the heart has reasons of its own, which reason does not know. May mga katwiran ng pag-ibig o ang puso na hindi maarok ng katwiran. Ika nga ni Balagtas o pag-ibig na makapangyarihan. Pag pumasok sa puso ni numan, nahamakin ang lahat. Magka-load ka lamang. Ay, matupad ka lamang. Okay. So rule number 5, avoid over-chronicling. Dates are unimportant. There's nothing wrong with stating the facts in chronological order kasi para alam natin kung ano yung pagkakasunod-sunod. But your initial outline of the case should list all the dates. Kailangan natin yan, yung chronology. But when you write your brief or memo, do not fall into the habit of starting every sentence with a date. Di ba? Sa information, isang beses lang naman siguro binabanggit yung date. Pagka i-final ni fiscal yung information, on or before ganitong date. Di ba? The accused, willfully, feloniously, unlawfully, and so on. As a general rule, most dates are not important. Kasi nga, hindi naman eksakto minsan ang pagkakaalala natin. Unless the exact date is important, leave it out. Instead, say that what the case is all about. Only the material facts and why they are important. Why would they work in your favor? Okay? Sabi naman ng isang lalaki dun sa nililigawan niya, kalendaryo ka ba? Niya, bakit? Manghihingi sana ako ng date sa'yo. Ayan. Okay. So headings are signposts. They should inform. Paano naman pagka ganyang heading ang nakita mo sa kalsada? Tutuloy ka pa ba? Yan ho ay actual picture na kinuha ko along Commonwealth Avenue. Ano? Ang ganda. Erection ongoing. Yung pala, nagtatayo sila ng mga poste para doon sa MRT 7. Pero ang ganda nung pagkakalagay. Erection. Ha? Para sa akin naman, wala namang ibig sabihin niya. Para doon sa ibang masamang iniisip, iba ang iniisip nila eh. So, if the legal argument portion of your opinion is 5 pages, you may not need to break it up. Sige, tuloy-tuloy lang ang sulat. But if it is longer than 5 pages, it should be separated into numbered headings. Why? The headings would give the reader context and they will signal where and when to safely take a break. Kasi minsan magkahaba-haba na nung binabasa, biglang nag-doorbell dahil dumating yung inyong online na in-order, na-istorbo ka na, di mo na alam kung saan mo babalikan. Whereas kung may heading, alam mo kung saan ka ng portion. Diba? Okay. So, the reader needs breaks in digesting complex materials. Lalo na yung mga millennial na mga estudyante ngayon, hirap sila kapag ang haba-haba ng binabasa. Kasi visual sila at hindi ano pa man. Separate the parts into subparts. And that would mean you have to put headings in these different parts of your written work. And another rule is write short paragraphs. Okay? Ano ba yung short paragraphs? Give the reader a chance to pause and digest what has gone before. Why? If you put 3 or 4 sentences with new information in each paragraph, that is enough. Okay? Ang problema natin, sometimes okay yung content eh. But form is also important. Make it look good. And learn from these people na ipinipresent yung sarili nila sa public, they have to look good. Even if they do not really look good. Ha? Ayan, si Mar. Marami nagsabi diyan kay Secretary Mar na dapat daw magbago na siya ng strategy kasi hindi siya nananalong presidente. May nagsabi sa kanya, tingnan mo, nung namatay si Ninoy, nanalo si Cory. Nung namatay si Cory, nanalo si Pinoy. Nung namatay si Jesse, nanalo si Lenny. At ngayon, na-dismiss pa yung protest laban kay Lenny. Hindi na nanalo si Marie. Okay, so obviously, the substance of the case is more important. In fact, it is most important, but to communicate the substance, you have to use the best form possible. Diba? Pag tinignan mo yung tao, hindi naman yung substance ang tinitingnan kaagad, yung appearance eh. That's why I would normally tell my students when you become lawyers, strive to look good. Why? Ano ba binabayaran ng kliyente? Di ba appearance fee? So you look good para magandang appearance. It is so much easier nowadays to make the document look good. Okay? Why? And daw sa darating na halalan, ito yung mga kandidato. Si Lenny at si Chel. Ang tambalan nila, leche. Okay? Ito naman daw si Manny Pacquiao at saka si Aimee. May nagsabi sa akin, ang tambalan nila, Pac-Me. Delikado. Si Pacman at si Aimee. Ito naman daw si Sara at saka si Bongo. Ang tambalan nila ay sabong. Maraming boboto dyan. Pero ito ang aking all-time favorite. At ito siguro ang iboboto ko pag kinuha niyang Vice President si Kiko Pangilinan. Ayan, po-Kiko tayo sa 2016 pa ito, no? Pero dapat 2022 na. Okay. So sabi ni Albert Einstein, we all know that light travels faster than sound. Okay? Yan daw ang common understanding. Probably that's why certain people appear to be bright until you hear them speak. Diba? Ayan. Liwanag. So kaya, yung document natin, strive to make it look good. Why? Form is very important. Remember the days when you have your old typewriter. Yung mga senior lawyers, no? Mga inabutan pa itong typewriter na ito. Inabutan ko yun, pero high school kami. Na pag nagkamali ka, mali na. Either i-erase mo yan at naka-imbento ng liquid eraser, pero pangit ng tingnan kasi maraming liquid eraser. Okay? Tapos, wala ka masyado magagawa except to italize or to underline. Paano na kung may carbon paper? Nagkamali ka, 5 copies yung ginagawa mo dahil nagtitipid ka, dahil walang Xerox, 5 yung buburahin mo. So, very tedious. Okay? So, nowadays, we are no longer confronted by that kind of problem because we can encode the documents, type it in your computer, and before you print it, you can edit. But the problem is sometimes, na-print mo na, saka mo lang na-realize, mali pala ito. So you go back. But it's quite easier compared to the old typewriter. So if you are nostalgic about the typewriter, the font that you use is Times New Roman. Okay? But ako, I would prefer Arial kasi mas madaling basahin. May korte akong napuntahan, nakatanggap ako ng order. Ang font na ginamit ay Comic Sans Serif. Ganda, no? Okay ito, Okay, consider the efficient use of paper rule. That if you try to examine and look closely, parang hindi naman masyadong efficient. Di ba? Dahil yung margin, pagkalaki-laki. Ginawa nga single space, pero ang lalaki ng margin. Okay, now, check your document carefully. So nagawa mo na, i-check. It's alarming how many times we see briefs with pages upside down or in the wrong order. Kasi nga nagmamadali. Why did it happen? Because we are cramming. We are preparing our pleadings a day or two before the deadline. E paano kung malaking issue ang involved dito and then you are filing your pleading on the last day, ay talagang magka-cramming ka. And chances are there would be mistakes, there would be errors. Okay? There are missing or blank pages, especially pagka you trusted your photocopying machine. Pagka photocopy, in-staple na, pinirmahan, hindi na in-examine, hindi na chinek. Okay? It certainly breaks up the flow of your argument. Imagine si judge binabasa yung iyong memorandum, pagkatapos, pag turn niya ng page, hala, blanco, o kaya upside down. Mainit ang ulo ni judge, tatapon na lang yan. Diba? Hindi naman natin alam kung itatapon niya or hindi. Basta make it look good. Then of course, check every page of every paper that leaves your desk. Why? Paano kung pinagkatiwala mo sa iyong clerical staff? He or she might be the most efficient staff. But remember, everyone is capable of mistakes. Baka hindi niya nakita, unintentionally, it's for you to check. Anyway, ikaw ang pipirma dyan, hindi naman yung staff mo. Now, in the case of Adez Realty versus Court of Appeals, sabi ng Korte Suprema, after due deliberation, the court and bank brush off as simply unsatisfactory the incredible counsel's explanation that it was his secretary who committed the mistake. Maraming ganyan. Pag siya nagkamali, itinuturo yung secretary. Okay? This passing the buck stance of counsel was already aptly rejected by the court, making the law office secretary or clerk or messenger the scapegoat or patsy for the delay in filing of pleading, motion, and other paper for the lawyers. The dereliction of duty is a common alibi of practicing lawyers. Ala, alam pala ng korte ito nang itinuturo ng mga practitioner ay yung office staff or yung kanyang clerk. Okay. Now, like the alibi of the accused in criminal cases, counsel's shifting of the blame to his office employee is usually a concoction to utilize to cover up his own negligence, incompetence, indolence, and ineptitude. For how could the secretary have divined the phrase without notice to the actual occupants of the property, Adez Realty, without counsel dictating it word for word? Okay? So hindi daw ito may isip ng office secretary kung hindi idinikta ng abogado mismo. Kasi merong falsification na ginawa yung mga abogado rito. Could it have been a providential mistake of the secretary, as it was very material and on which could have hinged on the fate of the litigant's cause? Whatever be the truth in this regard, counsel cannot elude administrative responsibility, which borders on falsification of a judicial record, to which, by his inveigling, he unfortunately drags his secretary. So alam naman po ng Korte Suprema kung ito talaga ay pagkakamali ng abogado o pagkakamali ng kanyang secretary. Indeed, by no means can he evade responsibility for the vicious intercalation as he admittedly dictated and signed the petition. It is the bounden duty of lawyers to check, review, and recheck the allegation in their pleadings. So that is our duty, that before every pleading leaves your desk, you check it. Although talagang, dahil nga tao lamang tayo, minsan may nakakalusot. No matter how hard, you check. But please, check just the same. Iba yung check sa check. Okay. More particularly, the quoted portion, and ensure that the statements therein are accurate and reproductions faithful down to the last word and even punctuation mark. Kasi that's the reason why pag kinote natin yung desisyon ng korte, hindi natin pinapalitan. Ngayon, kung may pagkakamali doon, sa tingin mo mali, lagyan mo ng SIC. Ano yon? May sakit. Hindi, sick. Meaning, talagang mali yon. You lifted an erroneous part and it is not your error. Diba? Yeah, minsan may mga, ang Supreme Court may mga decision na ang daming sick. Ibig sabihin, may sakit yung lawyer na nag-submit ng pleading. Okay. The legal profession demands that lawyers thoroughly go over pleadings, motions, and other documents dictated or prepared by them, typed or transcribed by their secretaries or clerk, before filing them with the court. Why? As I said earlier, it is not the clerk or the secretary who would be held liable because he or she was not the one who signed the pleading. It is the lawyer who signed the pleading. So you own the mistake. Okay? Teka, may na. Ayan. If a counsel is bound by the acts of, the client is bound by the acts of his counsel, more reason should counsel be bound by the acts of his secretary, who merely follow his orders. Ayan. Okay? Wherefore, the lawyer was what? Ayan. Disbarred effective immediately. Kasi nga, may misrepresentation naman dito na may sinasite na decision, pero yung portion na kinuha niya lifted supposedly from a decision to favor his client was not really in the decision of the court. So there was misrepresentation. And a lawyer shall not do any falsehood nor consent to the doing of any in court or even outside the court. That's in our lawyer's oath. Diba? So the lawyer was held liable, and because of such intentional misrepresentation, his cherished license was forfeited by the Supreme Court. So the lawyer was disbarred. Okay? Now, keep it short and simple. That's rule number 10. You must strive to write succinctly. It is much harder to write a short brief than a long one. Teka muna, pagka brief, di ba maiksi? Wala namang brief na hanggang tuhod. That's why it's called a brief. It should be short. Hindi, mas mahaba yung short sa brief. wala namang short tapos nilagyan ng brief. Yung mga superhero lang yan na nasa labas yung brief. But the brief is shorter than the short. Too much space, however, is a temptation to write all or more than all, about the subject. Diba? Kaya nga, I would normally advise my students, when you answer my questions in the exam or even in the recitation, try to give me short answer. And that would help you in the bar. Just say what you mean and mean what you say. Sorry to mention this, I would normally tell my students, bibiro lang naman ako, do not engage in foreplay. You just say what you mean and mean what you say, especially in the bar exam. Okay? Now, make every word count and your document will be much more convincing. Remember, yung ating Microsoft Word, may word counter yan. Tingnan nyo doon sa bandang baba, sa kaliwa, nandun yung word count ninyo. But do not be so conscious about the word count. Alam nyo naman yung estimate yan, masyado nang mahaba. The reader might think that you know more than you wrote, not less. Sabi nga sa inyo, nag-digest ng 20 pages na kaso, yung digest niya, 21 pages. Hindi niya naintindihan. Okay? Kaya nga, 1 page lang dapat yung digest. Okay. So take a look at this case of people of the state of California versus Orenthal James Simpson. Ang sabi ni Johnny Cochran, yung abogado ni O.J. Simpson, if it doesn't fit, you must acquit. That's the opening statement, addressing the statement to the members of the jury. Because apparently, there was a glove used by the one who killed the wife of O.J. Simpson. Yung gloves ay mas maliit sa kamay ni O.J. Simpson. So if the gloves would not fit, then he's not the assailant. He's not the accused. He's not the one who perpetrated the crime. You must acquit. But he put this in a very catchy sentence. If it doesn't fit, you must acquit. And his client was acquitted. But it depends on the situation. Okay. So, however, do not file, especially to the Supreme Court, a very short brief or memorandum. Okay? A petitioner's counsel was warned by no less than the Chief Justice of the Supreme Court at the time. We draw the attention of the parties to a matter of great concern to the legal profession. Delikado pagkaganyan ng mga wordings, ano? Petitioners and their counsel, pinanggit yung pangalan ng abogado, hindi ko nababanggitin, nasa desisyon naman ng Korte Suprema si Atty. Alcantara, submitted a 4-page memorandum that clearly contained neither substance nor research. Imagine, memorandum containing 4 pages. It is absolutely insulting to this court. That's a case of Social Justice Society versus Atienza. Ang abogado ng mga petitioner, para paalisin yung oil depot dyan sa Pandacan, Manila, ay nag-file ng memorandum sa Supreme Court with only 4 pages. And according to the Supreme Court, that is insulting. Why? We have always tended towards judicial leniency, temperance, and compassion to those who suffer from a wrong perception of what the majesty of the law means. But for a member of the bar and an officer of the court to file in this court a memorandum of such an acceptable quality is an entirely different matter. Imagine, you are filing a petition or a memorandum to the Supreme Court, give it your best. Di ba? Siguro, dahil matagal ng practitioner, sanay na siya mag-file ng memorandum, dapat paiksiin natin. Meron kayong efficient use of paper rule. Diba? It is indicative, less of a personal shortcoming or contempt of this court and more of a lawyer's sorry descent from a high sense of duty and responsibility. Okay? Meron ka naman siguro mga staff, utusan mo na mag-research. But do not let your staff, who is a non-lawyer, prepare your pleadings. Why? Ay, may mga desisyon ng Korte Suprema that preparation of pleadings is practice of law. And under the CPR, you do not delegate to a non-lawyer a task that should be performed by a lawyer. Preparation of pleadings is practice of law. That is covered in the term practice of law as defined by the court in that old case of Cayetano versus Monsod. I know you're familiar with that case, di ba? Now, as a member of the bar and an officer of the court, a lawyer ought to be keenly aware that the chief safeguard of the body politic is respect for the law and its magistrates. And I used to say in my legal ethics class, even if you know the judge and you know him not to be a respectable person, you call him your honor. You respect the position, not the person anyway. Okay? And of course, the inability of counsel to prepare a memorandum worthy of this court's consideration is an ehemplo malo to the legal profession as it betrays no genuine interest in the claim in the cause he claims to espouse? Or did counsel think he can earn his moment of glory without hard work and dedication called for by his petition? Maganda yung kanyang petition eh. Ang problema lang yung pagsasubmit nung kanyang pleading, that is too short. So wag 4 pages, make it 4.5 naman siguro. Okay. And then rule number 11. Ito 100 rules ito, 11 pa lang tayo. Kaya yan. Use no talking footnotes. If something is important enough to be in a footnote, it is important enough to be in the text. Okay, ano ba yung footnote? Yun nasa ilalim, kaya footnote. Ano pa? Footnotes detract from readability. Encountering a footnote is like going downstairs to answer the door while making love. Delikado yan. Ha? Okay. Then of course, don't let footnotes swallow the page from the bottom as in a law review article. Kasi pag may mga articles, yung footnote somehow, 3/4 ng pages, puro footnotes. 1/4 lang yung content. Pagbalik ta rin na lang natin. Dapat konti lang yung footnotes. Okay? Your goal is to communicate, not to build a resume. If you make your document look like a law review article, it will be just as unreadable. Wala naman masyado nagbabasa ng mga law journal. Diba? Okay. But citation should go in footnotes. Cluttering up your document with jumbles of letters and numbers makes it almost totally unreadable. Kaya nga, nagna-number tayo. Today, it's very easy to put footnotes. Diba? Kasi dun sa, lalo kung ginagamit ninyo, pareho naman siguro tayong ginagamit, Microsoft Word, meron dyan insert sa taas. Alam nyo yan. Tapos, nakalagay footnote. So, ilalagay nyo doon. Problem is, dapat may separate list kayo ng footnotes. Kung ano yung number 1, ano yung number 2, kasi minsan na-jumble yan. Even the Supreme Court was not spared from that kind of dilemma, as you would know later on. Diba? This practice should see, especially now that footnoting reference is simple. So, yung citations ninyo, wag nang idudugtong doon, no? Lalagay na lang doon sa baba. So, you would see just superscription of numbers. Tapos, yung number na yan would correspond to your footnote. Okay. So, magiging readable yung ating document if you do that. Now, do not fail to cite your source or reference. Because if you fail to do so, something bad would happen. Why? Kasi research ho yan eh. In one case involving a UP student, the degree was revoked. Okay? So ito, may isang PhD student, Doctor of Philosophy, major in Anthropology. By the way, lahat ng abogado ngayon, by virtue of LEB memorandum, we are now doctors, juris doctor, okay? Or doctor of jurisprudence. Ang sabi naman ng Commission on Higher Education, hindi daw ito equivalent sa PhD. Kasi raw yung PhD ay research-based. OMG. Diba? Ayaw nilang i-recognize. That's why yung mga lawyers na nag-a-apply sa mga for a teaching position, carrying with them that qualification issued by the LEB, yung may mga ibang eskwelahan, ayaw tanggapin. Ako, sabi ko, hindi po pwede. Kasi CHED has nothing to do anymore with the legal profession. The Commission on Higher Education and the Republic Act 7722 is in charge of all colleges and universities. But legal education, law schools, they're different. Why? We are now covered under the authority of the Legal Education Board and the Republic Act 7662. In fact, nauna pa yung charter ng Legal Education Board than the charter of the CHED. So hindi na dapat nakikialam ang CHED sa law schools. So, ano man ang issuances ng LEB, that's legal unless declared illegal or unconstitutional by the Supreme Court. Hindi naman nagpa-file ng kaso ang CHED, puro lang press release na hindi equivalent sa PhD, yung JD. Ano ba ang problema nila? Kasi daw hindi tayo research-based. Napakadali mag-research. ako modesty aside, di naman sa pagyayabang, lawyer tayo, of course. At mayroon tayong doctoral. Ay ko sa mga estudyante ko, kung hindi ako nag-abugas siya at nagtuloy lang ako ng mga PhD niya, baka 7 o 10 PhD na ako ngayon. Why? Mas mahirap po maging lawyer. Alam natin pare-pareho yan. Not to over-glamorize our profession, but it's quite more difficult to become a law graduate, much more become a lawyer than to earn a PhD. Di ba? So, hindi naman with all due respect to the PhD holders, no? Yan bang PhD, puro hangin ang dala daw. Sorry, permanent head damage, sabi nila. Hindi naman lahat. Okay? Kaya, if you are now a law graduate, hindi na LLB, kasi dati-rati LLB, paglabas ng resulta ng bar, libo-libo bagsak daw. Sa mga Bisaya ba, liwat-liwat bar. Okay? So ngayon, JD na, Juris Doctor. Even if you are not a lawyer, for as long as you finish that Juris Doctor degree, program, ang sabi ng Legal Education Board, that's equivalent to PhD, doctoral degree, for purposes of employment, classification, and compensation. Okay? Kasi nung unang panahon, mayroong Supreme Court at saka CHED memorandum, together with the CSC, na pagka-lawyer ka, that's equivalent to master's degree. That's way back 1999 pa. Okay? But now, it's no longer master's degree. Kasi kung titingnan naman talaga ninyo, you finished law, that's 4 to 5 years after graduation from college, because you cannot be admitted in law schools unless you have a 4-year course. You finish a baccalaureate degree. So ganun din naman, hindi ka po pwedeng maging master's degree holder kung hindi ka dumaan sa baccalaureate degree. So pareho. Kaya dati master's degree, but right now, according to Legal Education Board, it should be doctoral degree. Paano ho kami na LLB ang aming kurso? There was another LEB memorandum. You go back to your law school and request your law school to issue another transcript and another diploma. At ilalagay na yung correct degree, ito yung tinawag na LEB na Great Migration, from LLB to JD. So lahat na tayo ngayon ay doctor, Juris Doctor. Huwag lang magpapagamot yung mga tao, patay tayo dyan. Okay, so ito nag-aaral ng PhD. Of course, on the last part of the PhD, at ito yung pinagsiselos ng Legal Education Board, ng CHED. Kasi raw, ang JD, wala naman thesis yung iba. Ano bang problema lang walang thesis? Yun lang pahirapan ka ng mga professor mo sa law school gabi-gabi. It is only in the law school classroom where a student experiences every night sleepless nights, mental anguish, social humiliation, besmirched reputation, wounded feelings, and moral shock. And we cannot even sue our professors for damages. Diba? Nagkaganyan ba sila sa classroom ng MA, ng MBA, ng PhD classroom? Walang ganun eh. Napakababait ng mga nagtuturo ng PhD. Diba? Ayan. So ito, on the final stage ng kanyang PhD, gumagawa siya ng dissertation. So copying from here and there, and then hindi niya binanggit yung mga sources niya. Unfortunately for her, during the defense, may defense yan no? May panel. So I used to sit in the panel kapag may mga PhD na magdi-defend ng kanilang dissertation. 2 out of 5, kinopyahan niya yung mga dissertation nito. Unfortunately for that lady, hindi niya inilagay sa kanyang bibliography. So sabi nung kanyang panel members, akin to These materials are lifted from my dissertation. Why did you not include my name? Sagot niya, inadvertence. Nakalimutan lang ho. Di nakagraduate. Kasi 2 out of 5, majority, pinayagan siyang graduate. But the 2 professors whose works were lifted and there was no citation, filed an administrative case. So despite na nakagraduate na siya. And the Board of Regent of UP decided to revoke the degree of this PhD student. Okay? Naibigay na Sabi niya, may vested right na ako dito. Now, She brought the matter before the trial court, and the trial court issued a TRO. It was affirmed by the Court of Appeals. So UP went all the way to the Supreme Court. And according to the Supreme Court, where it was shown that the conferment of an honor or distinction was obtained through fraud, a university has the right to withdraw the honor or distinction it has conferred based on academic freedom. What is academic freedom? Article 14, Section 5, Paragraph 2. Academic freedom shall be enjoyed by all institutions of higher learning. That's in the Constitution. Okay? And according to Batas Pambansa Bilang 232, the Education Act of 1982, sabi ng iba, 1982 pa yan, expired na yan. No, that's still a valid law. May mga amendments lang tayo, but that's still a valid law. Academic freedom is three-pronged freedom. One, academic freedom of the institutions of higher learning. Two, the academic freedom of the teaching and other non-teaching staff. Okay? And three, the academic freedom of the students. So on the part of the school, its academic freedom has three aspects. Number one, to determine who would be admitted to study. That's why may entrance exam. That's why the Supreme Court declared as unconstitutional LEB Memorandum Order requiring students who would enroll in the College of Law to pass PhilSat first. Pag hindi ka pumasa sa PhilSat, hindi ka papasok sa law school. Unconstitutional, sabi ng Supreme Court. Pimentel versus Legal Education Board, September 10, 2019. Although ang LEB naman ay nag-file pa ng motion for reconsideration. But until now, there's no decision yet. But kung walang decision ng motion for reconsideration, so we follow that it is unconstitutional. Di ba? Ganoon naman ang rule natin. Okay. Another aspect of academic freedom to determine what would be the subject offering. And another aspect of academic freedom of the institution to determine who would be admitted to teach. That's why, pagka ikaw ay magtuturo, nag-a-apply, but in law school, yung dati naming dean, hindi ko nababanggitin si Dean Riano, sabi niya, you do not apply to teach in law school. You should be invited. Okay? At yun ang tumatak sa isip ko na hindi ako mag-a-apply sa law school. I have to be invited. And fortunately naman, may mga nag-i-invite naman. Yung iba nga neto turn down na natin dahil hindi napapasok sa schedule. So part of academic freedom, determining who would be admitted to study. The Supreme Court said that includes determining who would be allowed to graduate. Eh what if nakagraduate na may vested right na siya? Sabi ng Korte Suprema, the university can still revoke that degree. Diba? So in this case, the Board of Regents' decision to withdraw private respondent's doctorate degree was based on records, including her admission that she committed the offense. Na kinopya niya, kaya lang ang reason niya, nakalimutan lang. Inadvertently omitted. But the court did not believe that. So, wala na yung kanyang PhD. Ano na? HND. Hindi na doktor. Okay? However, there is another. Ito yung sinasabi ko sa inyo, no, na ang reason dito ng researcher, nabura kasi yung kanyang footnotes. So remember the case of Vinuya versus Executive Secretary. Ha? Ang Chief Counsel ng mga petitioners dito na nagpapa-discipline doon sa isang justice, ay di ko napapangalanan si Atty. Harry Roque. Ha? Siya ang abogado ng mga petitioners dyan sa Vinuya versus Executive Secretary. That was the case of the Comfort Women. They were asking for compensation and apology, public apology from the Japanese government. So sabi ng Korte Suprema, you cannot do that individually. It should be done by your state. So ang problema, ayaw naman utusan ng Supreme Court ang Malacanang na hingiin ang apology at ang compensation from the Japanese government. So you read that case, no? Vinuya versus Executive Secretary, April 28, 2010. So nung lumabas ang desisyon, nakita nung mga petitioners, syempre kanilang lawyer, na yung desisyon ay kinopya from here and there. Citing American jurisprudence, American researches, American Law Journal, particularly Yale Law Journal. Without references. So without citation. So kaya on motion for reconsideration, the lawyer pointed out several lifting without citation. So, pinailan ng administrative case. Yung justice ng Supreme Court, not the chief, but the justice of the Supreme Court. Andyan yung pangalan. Okay? In resolving that case, ang sabi ng Korte Suprema, petitioner, of course, insist that it is not material in committing plagiarism. Intent daw is not material in committing plagiarism. Because all the writer has to do to avoid the charge is to enclose lifted portions with quotation marks and acknowledge the sources from which these were taken. But petitioner's theory ignores the fact that plagiarism essentially is a form of fraud, where intent to deceive is inherent. Their theory provides no room for errors in research, an unrealistic position, considering that there is hardly any substantial written work in any field of discipline that is free of any mistake. Totoo naman yan, nagkakamali ang mga tao eh. Kaya lang, ano ang kaibahan ng reason dito sa reason noong doctoral student ng UP? Parehong nagkamali. Di ba? Pero yung isa, tinanggalan ng degree. Pero yung justice dito, exonerated. So wala siyang intent to plagiarize. The theory places an automatic universal curse even on errors that is, in this case, have reasonable and logical explanation. Ano ba ang logical explanation? Sabi daw ng Black's Law Dictionary, in its 8th edition, plagiarism is the deliberate and knowing presentation of another person's original ideas or creative expression as one's own. Thus, plagiarism presupposes intent and a deliberate conscious effort to steal one's work or another's work and make it appear to be his own work. Diba? So, intellectual dishonesty nga naman yan. Dahil hindi sa'yo, but you're making it appear that it is your own. Tama naman yon. Well, according to the court, on occasions, judges and justices have mistakenly cited the wrong sources, failed to use quotation marks, inadvertently omitted necessary information from footnotes or endnotes. But, take note, these do not in every case amount to misconduct. So, walang kamalian doon. Nagkamali lang talaga. Okay? So, only errors that are tainted with fraud, corruption, or malice are subject of disciplinary action. So yung justice, walang ganyan, walang fraud, walang corruption, walang malice, so he cannot be the subject of disciplinary sanction by the court. Okay? Justice Del Castillo's act or omission were not shown to have been impelled by any of such reputable motives. If the rule were otherwise, no judge or justice, however competent, honest, or dedicated he may be, can never hope to retire from the judiciary with an unblemished record. O nga naman. Diba? Baka nagkamali lang talaga. So let us take it as is at its face value. Okay? So kumpara nyo na lang yung kaso na yan doon sa UP Board of Regents case. Okay? So yung isa daw justice, yung isa justice. Anyway, rule number 13, edit, edit, edit. Eh bakit napakadaming edit niyan? Kasi nga, typographical error, bad grammar, and misplaced paragraphs, which were not such a problem before computers, simply take away from your argument. Okay? Dati-dati pag sa typewriter, kung ano yung tinype mo, yun eh. Pero minsan sa computer natin, iba yung in-encode mo sa lumalabas. Lalo na kung meron kayong spell check. Di ba? At minsan tinignan ko, teka, English naman yung sinusulat ko, bakit puro may red underline? Yung pala, for whatever reason, yung language niya ay French. Di ba? So, nagulat ako, English naman to, correct English. Bakit underline? Kasi pag in-underline ng red, ibig sabihin, mali siya based on the language that you are using. So, be careful. I-set nyo yung language nyo at gawin yung default yung English, American, kasi may British, Australian, maraming variation yung English eh. So iset nyo lang doon sa ating standard na American English para hindi kayo magkakamali. Now, with new technology, always comes new pitfalls. Oo naman. Diba? So kung may spell check or grammar check, lalo sa cellphone, minsan, yung dictionary nyo naka-on. So may itatype kang words, inunahan ka na niya. Diba? That's why isisend mo na, teka, bakit ito yung word? Ganyan din minsan sa chat sa Zoom. Ha? Check nyo bago kayo, pag mag-chat kayo, i-check nyo muna bago nyo pindutin yung send. Ha? Or enter. Kasi minsan, pinapalitan ni Zoom, lalo na kung hindi naka-program na off yung dictionary, pinapalitan niya yung words ayon sa pagkakaintindi niya. So spell check can substitute wrong words spelled correctly. But that's not what you mean. Diba? Oh. Sometimes spelling mistakes can put you into trouble. A husband, while in an out-of-town engagement, saw the place. It's very beautiful. So, sent a text message to his wife. At ito yung kanyang message. I'm having a wonderful time now. Okay? Ito na, nagpahamak sa kanya. I hope you were here. Okay? Lang niya ka. Meron ka palang kasamang iba. Anong nagkamali? Kulang ng I. Diba? Oh, kaya be careful with how you spell the word. You might be in trouble kapag ka nagkamali ng spelling. Okay. Now, write short sentences. Nagising ang sleeping dragon. Okay. Write short and crisp sentences. And ano ba ang most underused punctuation mark in legal writing? Lagi nating hindi ginagamit. Period. Why? Basahin niyo yung mga pleadings natin mga abogado, myself included. Pagkahaba-haba. Okay? Puro kama. Kaya overuse na yung kama. Okay? More periods. Tulad dun sa labor, nagtuturo ako ng labor review at labor relations. Meron tinatawag na freedom period. So pag tinatanong ko sa mga estudyante ko, sir, ang dami naman period kasi it is the 60-day period before the end of the 5-year period of your collective bargaining agreement. Eh sir, ba't ang daming period? Sabi ko, okay lang yan. Sa labor man o sa tunay na buhay, mahalaga ang period. Problemang malaki pag na-delay. Okay? Kasi pag na-delay, magbabayad ka ng interest. Okay. So, long sentences are specifically difficult when they are put together, strung together. Ang hahaba yan. Ha? Sophisticated readers can understand longer sentences if they are constructed properly. But somehow, it's difficult to go through 10 long sentences at the same time. Okay? So break up the pace. Follow a longer sentence with a short one. Okay? The minute you read something you can't understand, you can almost be sure it was drawn up by a lawyer. Diba? Kaya ngayon mga contracts natin, ang hirap basahin. Now, eto, napakahaba nito. Tingnan itong example ng sentence na ito. No? So, ilang kama ang nakita nyo? 1, 2, 3. Oh, pero ilan ang period? Isa lang. Of course, lawyers like us would understand. But ordinary mortals will find it difficult, but ang haba-haba. This is what they call kilometric sentence. Okay? Just one sentence, pero it consists of a paragraph na. Eh, di ba dapat ang paragraph 2 or more sentences? But this is just one sentence and it looks like a paragraph. So we should avoid that as much as possible. And according to a writer, a lawyer is a person who writes a 10,000-word document and calls it a brief. 10,000-word brief pa ang tawag, appellant's brief. Okay, dapat marami tayong brief kasi sinasubmit natin yan from time to time sa korte. Okay, so try to simplify the sentence. Ito, tingnan nga natin ito. It is therefore to be hoped that you will undertake the creation of the necessary administrative modalities to ensure provision to recipient entities of requisite alimentary sustenance. How would normal people write that? Give us this day our daily bread. Ha? Ganun lang pala kasimple yun. Opo, this is the Our Father version of lawyers. Okay? Now, kaya nga daw when a lawyer dies, he has to be buried in a standing position. Bakit? Kasi daw, he has been lying all his life. Okay? Ay, hindi naman lahat. Marami pa rin naman tayong mga lawyers na hindi nagsisinungaling. Because lawyering is telling the truth, no matter what. Pwede nga. Okay. And then, as the English teachers would tell us, I have an English teacher here, ang sasabihin, active voice must be preferred over passive voice. Diba? Active voice, the subject performs the action denoted by the verb. Whereas, ito example, the lawyer saw the judge. Nilagari yung judge? Hindi naman. Then of course, in passive voice, the subject of a sentence is the recipient of the action. So let us convert that to passive voice. The judge was seen by the lawyer. So ang dating weak, stronger yung active. Kaya nga active di ba? Now, you use mainly the active voice because passive naman is not forbidden. But usually active is better because action is easier to understand. Kaya nga lagi sinasabi ng mga nililigawan, action speaks louder than words. Di ba? Ayan. Okay. So, nung tayo nasa elementary grade, sabi natin, Johnny tried to hit me. Nabully itong si Johnny. Now, after law school, iba na ang sinasabi natin. An attempt was made by Johnny to assault me. Bakit? Lawyering na yan eh. If there's no good reason, put back your sentence the way real people would talk. What's that? Communicating. Okay? Now, use dash, parenthesis, comma for degrees of emphasis. Okay? So you should avoid cluttering your document with too many incidental comments. Yung ilalagay mo sa parenthesis because you are trying to define the word or probably you are trying to explain the word that may not be too common or too familiar with your readers. No? A dash provides the greatest emphasis. But the next in degree is the parenthesis and then the comma. So yan, habang sinusulat na natin yung content ng ating document. Now, sometimes one word is usually enough. Hindi natin pakakahabain eh. Kaya lang pag nakakita kayo ng mga legal forms, no? Ayan, devise, bequeath, grant, bargain, and sell. Right, title, and interest. Make, ordain, constitute, and appoint. And they mean the same thing. Diba? So anong purpose niyan? Lawyers tend to use many words when one is more understandable. Sufficient number of can be written as enough. That point, we can use then. Kaya lang hindi na lawyerly ang dating. Di ba? For the reason that layman would say because. Okay? You can save on your paper. And you can save many trees in the process. Tayo mga abogado ang dahilan kung bakit maraming puno ang namamatay. Kasi gumagamit tayo ng maraming papel. Do not write filed a motion unless the filing itself has some significance. We can write moved, and they mean the same thing. Okay? Now, in the book, The Legal Writer, itong si Judge Mark Painter, I would normally quote him kasi maganda yung libro niya. Available ito sa Amazon, pero pwede nyo atang i-download yung soft copy for personal use. Kasi that would be compatible with fair use doctrine and there is no copyright infringement. At you do not sell that. Okay. Pero mas maganda pa rin yung meron kang kopya nung hard copy ng libro. I would appreciate that. No? So the legal writer, in 2012, sabi niya, pwede nating i-simplify yung mga ginagamit nating mga phrases or sentences or words. Okay? Ito, the means by which can be translated as how. Entered into a contract can be written as contracted. Filed a counterclaim, counterclaim. Filed a motion, moved. Okay? So marami ho siyang dito. And if you want, you can take a photo, a screen capture ninyo. It's all right. You can always do that para may reference kayo. No? Notwithstanding the fact that, we can write that, although. So that would save you on space. And you will be compliant with the efficient use of paper rule. Notwithstanding, despite, in order to tanggalan ng dalawang words, to. Diba? At this point, now. Okay? So you can save much on your resources like paper and ink. Filed an application, applied. Adequate number of, enough. For the reason that, because. In the light of the fact that, because. So ang daming pwedeng gamitin because. Di ba? So mas maiksi. Now, until such time, until. By means of, we can just write by. So malaki ang natipid nating space. As a consequence of, because of. So laki na natipid nating space. Is of the opinion that, believes. Okay? And they mean the same thing. However, there are instances that you would like to emphasize. Ang ginagamit natin, pakinggan nyo si Donald Trump pag nagsalita siya. In order to emphasize, ang sinasabi niya, very, very. Okay? Baka nagkasakit na yan. So, may suggestion dito, no? Na instead of using the word very to modify an adjective, you can use another adjective without using the word very as a modifier. So like very noisy, deafening. Okay? Very often, frequently. Very old, ancient. Very old-fashioned, archaic, and so on and so forth. Without using the word very. Kasi nga pag paulit-ulit, nakakasawa. Okay? Now, common ito, no? Na gumagamit tayo ng mga parenthetical numerals. Ano ba itong mga parenthetical numerals na ito? Especially irritating is the practice of spelling out numbers and then attaching parenthetical numerals. An example, na we learned this habit from the scribes who use quill pens to copy documents. Before Johannes Gutenberg invented printing press, books were published through copying. Yun ang pinakatrabaho ng mga monks noong unang panahon. Even our Bible, no? The Bible of the Christians and the Jews, yung mga scribes ang kumukopya. You want to have your Bible, you copy it. So in the process, dahil tao ang gumagawa, nagbabago. That's why one version of the Bible may be different from another version. Di ba? Kaya nagkakaroon ng mga inconsistency. Okay. Why? Because of the scribes who copied the original manuscripts. The Gospels, for example, they were not written during the lifetime of Jesus Christ. The oldest Gospel of Mark was written 50 to 60 years after the death of Jesus. Kaya marami nagsasabi, baka hindi totoo ito. Kasi 60 years na after sinulat. At hindi eyewitness yung sumulat. Okay? So yun ang problema. Now, anong example? The reason for this is to prevent fraud by making it difficult to alter. For example, no? Ito. The sum payable is expressed in words, also in figures, and there's a discrepancy between the two. Ayan. The sum denoted by the words is the sum payable. But if the words are ambiguous or uncertain, reference may be had to the figures to fix the amount. Saan ang galing yan? Sa negotiable instruments law. Well, understandably, the negotiable instruments law is one of the oldest laws that we have. February 3, 1911, nung maisabatas ang Act number 2031. So yan ay ilang daan taon na? Oh, noong 2011, 100 years old. Okay? So 110 years old na ang negotiable instruments law. So marami tayong nakikita, although the Supreme Court hindi pa rin umaalis dito sa ganitong ugali, no? Ang sabi, there were two, tsaka lalagyan ng parenthesis, number 2, accused, and 3, policemen present. Well, madaling basahin, pero that looks silly. Unless you're writing your opinion in longhand, and unless you believe the parties will alter the numbers, skip this noxious habit. So how do we write numbers? Ang rule sa journalistic writing If the number is 10 or less, you spell out. If the number is above 10, you write the figures. Kaya lang tayo, nakasanayan na nga natin because of that old habit of the scribes to write the words first, saka natin enclose in parenthesis yung figure. Humanap kayo ng lahat ng desisyon ng mga korte o anumang administrative body, even the NLRC. Di ba? Nakalagay yan. Yung amount in words and then the amount in figures. Sabi kasi na negotiable instruments law, mas madaling baguhin yung figures kaysa dun sa words. Okay? Lalo na pagka milyones na ang pinag-uusapan. Okay. And then, hyphenate phrasal adjectives like compound modifiers. Okay. The reader is somehow confused by nouns acting as adjectives or two adjectives together modifying one noun. Nako, yung mga grammar teacher. Ha? Sample, always hyphenate phrases like wrongful discharge suit or public policy exception or larger-than-life personality. Why? Kasi magkaiba ang meaning. Okay. A sign used to join two words to indicate that they are combined or they have a different meaning when they are combined. Like pick me up, rock formation, etc. So hyphen will also indicate the division of the words. Okay? Now, why do we need hyphens? Because working 24-hour shifts is not the same as working 24-hour shifts. Ano yung kaibahan? 24-hour shift, isang 24-hour. Tapos naman, 20 na 4 hours. That's the problem with English language. Pag nagbago ka ng hyphen, o alisin mo yung hyphen, ibahin mo, mag-iiba yung meaning. So, 24-hour shifts. Magkakaiba ng meaning yan. Okay? But in Filipino, 24 hours lang naman yan. Okay. Now, also use the serial comma. Serial comma. In a list of 3 or more, always insert the comma. Para saan yan? Some writers, especially non-lawyers, insist on omitting the last comma before end. Kasi kung may series ka ng mga salita, yung pinakahuli, sabi ng mga teachers ng grammar, huwag mo nalagyan ng comma kasi end na yun eh. But according to legal writing experts, do not omit the last comma before the word end. Because chances are that might change the meaning. So do not omit the last comma because doing so can cause misinterpretations. Okay? Then, avoid unnecessary preambles. And I'm here to stay. May mga chat po. Let us take this opportunity. Okay. Sige po. Thank you. Nag-CR break lang ho. Itong mahirap sa ano. But anyway, if there's one advantage that we have right now, yung nawala yung problema natin sa traffic. Kasi dati-rati kung ang lecture ko kay Jude ay 8 o'clock, I have to leave my house in Quezon City at 5 o'clock. Kaya normal hindi ako tumatanggap kay Jude dati ng lecture na 8 o'clock. Kasi ayokong malate. That's one thing na ayaw ko yung nalilate. Kaya kung alam ko na malilate ako, I would normally request for adjustment of schedule. So, avoid unnecessary preambles. Ano ba yung mga preambles? Ito yung mga introduction. Unnecessary preambles can weaken or hide the point they introduce. Kasi nag-concentrate na lang yung reader dun sa preamble. Now, it is important to add that. Normally, bago tayo magsalita, may mga preambles tayo, no? It may be recalled that. Common yan. That's a common. Those are common preambles in legal writing. In this regard, it is of significance that. Pwede naman dumiretso na lang. It is interesting to note that these are the most common preambles that a lawyer used. So take a look at the preamble of the 1987 Constitution. We, the sovereign Filipino people, imploring the aid of the Almighty God in order to build a just and humane society, blah, 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 etc. We do not get anything out of that. That's not a compilation of our rights. In fact, there are constitutions in the world that are functional without a preamble. One example is the Constitution of Cuba, na kung saan kinopyahan ata ni Emilio Aguinaldo doon sa kanyang 1898 Malolos Congress na nagkaroon ng 1899 Constitution, galing kinopya daw sa Cuba, walang preamble. But naalala ko yung panahon na all curriculum pa ang mga colleges and universities, meron tayong subject na Philippine Government and Constitution. At yumama ng gusto doon si Atty. De Leon dahil yung textbook niya ang ginagamit kahit sa eskwelahan all over the country, di ba? Ang problema doon sa mga nagtuturo na hindi naman abogado, and I think I was one of those who are victimized, tapos na yung semester, preamble pa rin ang nire-recite as if it is the most important part of the Constitution. So nag-concentrate sa preamble kasi ang ganda nga naman ng pagka-phrase, di ba? Oh. Is there anything important about the preamble? Well, it just gives an introduction. The purpose for which the document is framed. But there is one important word in the preamble of the Constitution. You have to be in love. If you're a Filipino, you must be in love. Why? If you are not in love, you are unconstitutional. Diba? Pero sabi niya, love is an island of emotion that is entirely surrounded by the sea of expenses. Why? You can give without loving, but you can never love without giving. So I do not want to fall in love because I have nothing to give except my body. Delikado tayo dyan. Okay. So avoid the unnecessary preambles. Rule 23. Malapit-lapit na. 200 rules lang ito. Purge law speak. Ano ba ibig sabihin nito? Avoid legalese. Hereinafter, aforesaid, the defendant herein, the herein petitioners, pwede naman dumiretso dun sa petitioner. And the like, do not add anything but wordiness and detract the readers from reading your document. Wala na, gusto bubasa. Pagka sinulat na abogado, mahirap basahin eh. Pero if there's anything important, gusto nyo ng matinong relasyon, asawa, boyfriend, girlfriend, humanap kayo ng abogado. Matinong relasyon dyan. Why? Yung batas nga, inuunawa. Ikaw pa kaya? Okay. So many studies show that legalese is the #1 complaint of non-lawyers. Reading pleadings and court decisions. Kaya ayaw magbasa ng layman ng mga desisyon ng Korte Suprema kasi #1, English. #2, ang hirap unawain. That has been a common expression or observation among non-lawyers. Kaya nga ako, when I talk to my clients, we use a language that we both understand. Diba? Kasi yung unang rule natin, know your audience. So if you are talking to your client, of course, na-size up mo na kung ano ang educational background ng kliyente mo. Pagka yung kliyente mo Inglesero, mag-English ka rin. Diba? Pero ako kasi, mga 80% ng ating practice dati nasa labor, and 50% of that 80% ay mga illegally dismissed employees na karamihan, security guard, factory workers. So I have to use their language. Okay? Why? Mag-law speak ka, hindi ka maintindihan. Okay? Sabi nung kliyente, attorney, nakakulong yung mister ko, wala naman siyang kasalanan, hinuli na lang siya, wala namang warrant. Ano ho bang gagawin natin? Sabi ng abogado, okay, mag-alala. Magpa-file tayo ng petition for writ of habeas corpus. Sabi ng kliyente, mahal ho ba yun? Kasi sabihin niya, magpa-file tayo ng pleading sa korte at sasabihin natin kay judge na wala naman dahilan, palayain niya yan. Pag naintindihan kasi minsan ng kliyente, hindi nagbabayad eh. Pag hindi lang naiintindihan, malamang mahal yun. Okay? So yan ang dahilan kung bakit meron tayong mga legalistic term minsan. Ayan. Okay. So, sabi naman itong American-based guitarist na ito, people are afraid of the things they don't understand. Kaya pag di lang naiintindihan, sige, bayad ka na lang para maintindihan mo. Huwag naman ganun. Okay. Now, Daniel Webster was famous even when we were in first year law school because of that case of Dartmouth College versus Woodward. Ano ba yung Dartmouth College versus Woodward? Constitutional Law 2. Sabi ng Korte Suprema, sabi ni Daniel Webster na kinakot ng ating Korte Suprema, due process of law is a law that hears before it condemns, proceeds of an inquiry, and renders judgment only after trial. Those were from the mouth of Daniel Webster. Yung abogado doon sa Dartmouth College versus Woodward in his closing statement addressed to the jury. Okay? So minsan, nakakatulong yung a few res ipsa loquitur o respondeat superior. Diba? Latin eh. Pero, sabi ni Daniel Webster, do not litter your opinion or your written work with what he called mangled pieces of murdered Latin. Diba? Minsan, kahit yung Supreme Court, no, although they have that privilege and the luxury of using Latin, kasi Latin is already a dead language. Why? Wala nang gumagamit nito eh. So pag dead na yung language, sabi ng mga linguist, mas maganda nang gamitin kasi hindi na nagbabago. Wala nang nadadagdag, hindi na yan nangihiram. Hindi katulad ng mga active languages today na nangihiram eh. For example, yung boondocks. Nasa English language na yung boondocks na yan. Nasa atin, bundok, di ba? Mountains. And another word, that Filipino word, that has been admitted into the English dictionary, at least Oxford, ay yung katiponize. Okay? Ano yung katiponize? To organize. From the Tagalog word katipunan, na yung KKK. Kataas-taasan, kagalang-galangan ng mga anak ng bayan. Na nung uso pa ang sinihan, nandun din sila sa KKK. Kataas-taasan, kasuluk-sulukan, at kadilim-diliman daw na lugar. I do not know. Okay? So, now, parties have names. So have you ever represented a client without a name? May kanta dati, a horse with no name. The parties have name. Okay? So don't go through your whole brief calling parties plaintiff, appellant, defendant, appellee, or the like. Minsan nakakalito yan eh. Bakit? Nagbabago kasi yung designation ng ating kliyente. Well, appellant would be enough, but it is better to call the parties by their name. When we use procedural titles, the reader must translate to understand what we mean. Of course, lawyers and law students probably would understand who is the petitioner and who is the respondent. But an ordinary layman would not understand sino ba yung respondent. Okay? In fact, sino ba yung plaintiff at sino yung defendant? And as the case progresses, umaakyat sa ladder ng ating judicial hierarchy, the title of the parties would change. Diba? So yung dating plaintiff may somehow become the appellant or the appellee, depending on what happened in the trial court. Okay? So, procedural titles change, as I already discussed with you, throughout the case. Pero yung name ng kliyente mo would not change. So it can help if you would be using the name of the parties involved. So using names also humanizes your client. Because even corporate names sound much more human than plaintiff appellant. Diba? Kaya nung nawala itong ABS-CBN, maraming natuwang mga misis eh. Kasi yung mga mister nila nawalan ng bisyo, ABS-CBN. Alak, babae, sugal, cabaret, bar, nightclub. Okay, meron daw ganyan eh. At natuwa sila, dahil lang natira na lang ay GMA. Konti na lang kami. Gentleman all the time. Okay, so be consistent however. Do not switch back and forth between appellant and de la Cruz and plaintiff. Eh, malalo malilito ang magbabasa. So sino ba talaga siya? Okay? Ang ginagawa dyan ng Supreme Court at na ibang korte, di ba? Babanggitin yung pangalan, ABS-CBN Corporation, ABS for short or for brevity. Para pag ginamit mo siya, may warning na itong nagbabasa na ito pala yun. Kasi minsan pagkahaba-haba naman ng pangalan, so gagamit ka ng shorter. Okay. Rule 26, use quotations sparingly. Kasi pagka puro quotation yan, baka sabihin ng korte, teka muna, ano ba ito? Literary piece ba ito? Na pinagtagpi-tagping quotations. Okay? You should explain how the cited cases support the theory of your case. Do not use a lengthy quotations, a few lines at most. O ito, yung sinabi ni John Donne. Ano lang ang natandaan natin? Yung first 5 words. No man is an island. Yun lang ang naalala natin. Pero yung kabuuan, napakahaba pala nung sinabi niya ni John Donne in its original version. But what do we recall? As the days go by and years go by, no man is an island. 5 words lang out of a very long paragraph. Diba? Okay, no one reads a long black quotes. Kahit naman tayo mga abogado, tinatamad din tayo minsan magbasa ng pagkahaba-haba eh. Okay, may mga tao naman na tanong ng tanong. Iba naman ang ginagawa sa in-advise mo. Yan ang tawag sa kanila. Diba? Babalik na naman sa iyo, attorney, bakit ganito? Di ba ito na sinabi ko sa iyo? Iwanan mo na yan. Mahal ko pa siya. Diba? Ganyan na minsan sa mga bawsi cases. Ang advice ng abogado, iwanan mo na, sampahan mo na ng kaso para makahingi tayo ng temporary protection order. Mahal niya. Hindi niya maiwan. Ay, talaga naman. Okay? Talagang inaantay ko yung araw ng mga utak at hindi yung araw ng mga puso. Ngayon, people skip the single space block and go on. Okay? Unless the case you are quoting is from is exactly on point, just quote the most relevant and persuasive part. But do not take it out of context. And please do not quote from a dissenting opinion. May isang abogado, pinagalitan ng Supreme Court, although winarningan lang naman. Do not quote from a dissenting opinion. Sabi niya, Your Honor, the dissenting opinion somehow, sometimes, becomes the decision of the majority. Then wait until it becomes the decision of the majority before you can quote from it. Okay? Kasi minsan, there is that tendency to quote from a dissenting opinion pagka nag-a-agree yung dissenting opinion sa gusto natin. Like for example, ang paborito nating i-quote na dissenting opinion sa taxation law, that the power to tax does not include the power to destroy for as long as this court sits. Sabi ni Justice Oliver Wendell Holmes. Right? But that is a dissenting opinion. In that case of Panhandle versus the state of Mississippi. But we are quoting from it. Bakit? Masarap pakinggan. Kasi ayaw natin magbayad ng tax. Okay. And then use persuasive language. If you can explain your case, how can you expect the readers to understand it? Gamit daw ng simile, metaphor, use mainly the present tense. Use logical cause and effect connectives. Use powerful verbs and strong adjectives. At makakatulong yung pag-iwas dun sa very. Okay? And continue your research. There's no substitute for a thoroughly researched pleading. Napakadali na ngayon yan. Bakit? You have your Google. Mananalangin lang tayo sa 3 makapangyarihan. PLDT, Globe, or kung ano man yung provider ninyo. Converge ba? Na huwag nilang pabayaan ang ating internet connection at sana tuloy-tuloy. Kasi tuloy-tuloy din naman ang bayad natin eh. Check every citation periodically. Kasi mabilis ngayon ang pangyayari. Baka yung iyong majority decision na-overturn na by another decision. So easy nowadays if you have your internet connection. Note the evidentiary records of the case. And of course, enjoy the experience and the practice of law. Like sa mga bagong lawyers, huwag kayong matakot mag-practice. Practice, go to court. Why? Doon tayo natututo. Paano pag nakulong ang kliyente? Huwag matakot. Ano ba ginawa mo? Practice. Nakulong. Sorry. Practice lang naman. Nakulong. Ano ba ginawa? Trial. Nakulong ako. Di nag-error. Sorry. Trial and error. Wag. For as long as you have done your best to protect the interest of your client, there's no reason to be afraid of not getting what you want. Because what you want may be different from what the law says. Okay? So, ang sabi dyan, practice is to perform or work repeatedly as to become proficient. ina-attribute nila kay Aristotle, we are what we repeatedly do. Excellence then is not an act, but it is a habit. So pag lagi mo nang ginagawa, it becomes a habit. Okay? So ito na, dahil lahat tayo lawyers, di ba? A lawyer is a person who practices law, etc. Now, kung gusto nyong malaman yung mga bago sa labor, ito ang latest edition, 2019. Kapangalan ko yung author. Available sa Rex Bookstore, even online. Buong labor code yan. Kayang-kaya nyo yan. No? Ito rin, constitutional law. The latest, Rex Bookstore. Ginagamit ito ng mga estudyante natin sa law school ng San Sebastian, Arellano at ng pamantasan ng lungsod ng Maynila. But I never force my students to buy my books. I would normally tell them, you can use any book you want. But there are books which I have written, pwede natin gamitin dito. So hindi ko kayo pinipilit na bumili. That's for the record. I do not force you to buy. But one friendly advice. Lahat ng tanong ko sa recitation at sa exam, diyan manggagaling. So may choice kayo. Okay? I'm not forcing them. So public international law, nandiyan na rin yung away ng Pilipinas at ng China. Pati yung desisyon ng arbitral panel na ayaw nating ipatupad at ayaw naman umalis ng China sa Scarborough Shoal. Kasi naniniwala ang China na sila at ang Pilipinas ay mag-shoalmate. So ayaw nilang umalis sa Scarborough Shoal. Okay? At ito naman sa kasaysayan, klinarify natin, saan ba talaga pinatay si Bonifacio? Sa Mount Nagpatong, sa Mount Buntis, sabi ni Saiden, Mount Nagpatong, sabi ni Professor Agoncillo. Dito sa Mount Nanganak, kasi Nagpatong, Buntis, nanganak na dyan. Sa Rex Bookstore yan. Okay? Dahil ako naman ay lisensyadong guro, you have the law and the teaching profession in the Philippines, sa CNE naman yan. And of course, kung gusto maging teacher, syempre kailangan mag-review. Para sa licensure exam for teachers, meron tayo niyan. Okay? At kung hindi abogado at hindi pa law student o law student pa lang, gusto maging permanent sa gobyerno at hindi lamang job order, ay kailangan pumasa sa civil service exam. So meron din tayo niyan sa National Bookstore. Pasensya na, medyo matinding pangangailangan. Okay. And then also, you have philosophy sa Rex Bookstore. You want to travel around the world without leaving the comforts of your home. You have world geography sa Rex Bookstore din yan. You want Asian civilization, meron tayo sa Rex Bookstore. And then ito yung history of Philippine educational system from pre-Hispanic up to the present. Sa Phoenix naman yan. And of course, si Rizal ay napaka-importanting figure sa ating kasaysayan. Meron din tayo yan sa national. At syempre, nagkaroon ng K-12. Kailangan natin kumita. Kailangan natin makatulong dyan. So kaya nag-publish tayo ng libro sa sociology. Part ng K-12 yan. And then of course, yung aking roommate who happens to be my wife, ayan, may libro din siya. Okay. So tayong mga abogado, sabi natin, we keep on talking. But remember this, no? I would normally end my lecture with this, the heart. Anyway, buwan ng mga puso. Take a look at the heart. You remove letter T, you have the word here. You remove letter H, you have the word ear. So in the middle of the word heart is the word ear. And if you try to cut both your ears, but please do not do this at home, you'll form a heart-shaped object. So what does it imply? Our ears are the gateways to our heart. You'll never know how to love unless you know how to listen. At kung may mga gusto pa ho kayong malaman sa iba pang subjects, ayan, pwede kayo magpunta sa YouTube channel na yan at mag-subscribe kayo para makita nyo. Nandiyan din ho lahat ng mga jokes naka-upload na dyan. Kasi gusto nila gumawa ako ng libro sa jokes. Ay kung baka hindi seryosohin at pagtawanan lang. So nandyan, matatagpuan nyo sa YouTube channel na yan yung mga jokes. And of course, at the end of the day, be grateful. Okay? Why? Merong isang Persian poet, si Sadi, sabi niya, I weep because I have no shoes until I saw a man with no feet. Okay? So, be thankful na kahit na nasa pandemic tayo, may chance tayo na makapag-MCLE. So spread the word para maging busy itong si Jude sa ating MCLE. So maraming salamat at magandang umaga po sa inyong lahat.